Chapter 4, Special Provisions. Welcome to your Euro Patent Brief Journey with Baris. We're about to dive into the details of applications relating to nucleotide and amino acid sequences. This can be a technical and precise area, but don't worry, I'm here to guide you through each step, carefully, patiently, with as many pauses as you need. Take a deep breath, let's get started. 5. Applications relating to nucleotide and amino acid sequences. Now, let's begin. If nucleotide or amino acid sequences, as defined under Rule 30(1), are disclosed in the European patent application, they must be represented in a sequence listing. But, not just any listing. It must comply with WIPO standard ST26. Let's pause here. Take a moment to reflect. WIPO standard ST26 is now mandatory. This standard, globally recognized, includes recommendations in Annex 7 on how to avoid added or deleted subject matter when converting from the old WIPO standard ST25 to WIPO standard ST26. The EPO relies on these recommendations during examination. Remember, WIPO standard ST26 is crucial for sequence listings. Let's move on. Each nucleotide or amino acid sequence that exceeds the minimum length, as defined by the standard, must be listed in the sequence listing, even if it's just a fragment of another disclosed sequence. Yes, every sequence. Even a small fragment. Take a breath. This is important, everything needs to be listed in the correct form. The sequence listing must be filed electronically. That's right, only in XML format. You can use EPO Forms 1001E, 1200E, or 1038E, in EPO Online Filing or Online Filing 2.0, or submit it on an electronic data carrier. But, no paper filings. No PDFs. The sequence must be submitted correctly, in XML. Take a pause here, to make sure that detail sticks. Now, if you file more than one sequence listing on the filing date, only the standard compliant listing will be used as the basis for the search. This is backed by the decision of the President of the EPO, from December 9, 2021, and several notices and decisions from the EPO, most recently from April 24, 2023. Take a breath. That was a lot to process. Let's talk about what happens when a sequence listing is filed or corrected after the filing date. When this happens, the applicant must submit a statement confirming that the updated listing does not contain matter that goes beyond the content of the application as filed. This is critical. The sequence listing filed later will not be considered part of the description, and therefore, it won't be published with the European patent application. Let's pause and breathe. This distinction is important. Late-filed sequence listings are not part of the description. If a sequence listing, that's part of the description, is corrected or amended, a complete new sequence listing must be filed. The corrected or amended listing must comply with the applicable WIPO standard. For applications filed on or after July 1, 2022, they must comply with WIPO standard ST26. For applications filed before that date, the listing must comply with WIPO standard ST25. Take a moment here. Breathe deeply, and let that distinction sink in. The receiving section will inform the applicant of any deficiencies regarding the sequence listing or the required statement. An invitation will be issued to correct these deficiencies, and a late furnishing fee will be imposed, all within a non-extendable period of 2 months. The late furnishing fee compensates for the administrative efforts of issuing this communication and for delaying the transmission of the application to the search division. However, the late furnishing fee doesn't need to be paid if the standard compliant sequence listing is filed after the filing date, but before the receiving section issues the communication under Rule 30(3). Take a breath. Timing is key here. If the requirements of Rule 30 aren't met in time, including the payment of the late furnishing fee, the application may be refused, as stated in Rule 30(3). This also applies if the sequence listing is filed in the required format, but still contains deficiencies. And the EPO will not issue another invitation to fix the deficiencies unless the first invitation didn't fully address the issues. This was clarified in case J7/11. Take a breath here. Refusal is a serious outcome. Let's move on to 5.1, Sequence Information Filed under Rule 56. The possibility of filing a sequence listing as a missing part of the description under Rule 56 is rare. This rule applies when it's obvious from the application documents that part of the description seems to be missing. Here's an example. The description refers to sequence identifier numbers, but doesn't include the sequences themselves. Even though the disclosure is missing in the form of a sequence listing, the receiving section is not expected to treat this as qualifying for Rule 56. Let's pause here and take that in. However, the applicant can file the missing parts on their own initiative within 2 months of the filing date. Under Rule 57J, any late filed sequence information will be checked for compliance with Rule 30(1) and the rules set by the EPO President. If the late filed sequence doesn't meet the requirements, the receiving section will send a Rule 33 communication asking the applicant to fix the deficiencies. If the late filed sequence does comply, no communication will be sent, and the late furnishing fee won't apply. Let's pause here and make sure we understand this process clearly. Whether the late filed parts result in a change of the filing date or maintain the priority date, the communication under Rule 33 will only be sent after the 1-month period for withdrawing the late filed parts has passed. If the applicant inserts a sequence listing as a late filed part, whether it's standard compliant or not, it will be considered part of the description on the filing date and will be published with the application. Let's take a breath here. It's important to distinguish between late filed sequence listings and those submitted with the original filing. There's a difference between cases where 1. The complete sequence information is in the description, but no standard compliant listing is filed. 2. The sequence listing is incomplete. 3. The listing doesn't comply with the applicable WIPO standard. In all these cases, Rule 30 applies, and the applicant will be invited to file a standard compliant sequence listing. Take a moment to process that. Let's move on to 5.2. Sequence information filed under Rule 56A. Under Rule 56A, erroneously filed sequence listings can be corrected. Now, let's dive into 5.3. Sequence listings of an application filed by reference to a previously filed application. When an application is filed by reference to a previously filed application, and that previous application contains sequence listings, the listings form part of the application as originally filed. However, if the sequences only appear in the claims and not in the description or drawings of the earlier application, and the claims aren't included in the reference, the sequence listing must be filed separately. Pause and breathe here. If the sequence listing is filed with the European application's filing date, it will be published with the European patent application. Take a moment here to process this information. A sequence listing filed after the filing date of the previous application is not part of the description and must be filed separately for the European patent application. If the previous application isn't available to the EPO, the applicant must submit a certified copy and any required translation within 2 months of the filing date. Let's pause here. Make sure you remember the 2-month window for certified copies and translations. If the sequence listing in the previously filed application doesn't comply with WIPO standard ST26, the applicant will be invited to submit a standard compliant listing. If the previous application was filed with another office, the applicant must ensure compliance with Rule 31. Take a breath. We're almost there. Now let's talk about divisional applications in 5.4. Sequence listings of a divisional application. A divisional application must also meet the requirements of Rule 30, even if the sequence listing in the parent application was in ST25 format. It must be converted to ST26 format. To avoid the risk of adding or losing subject matter during conversion, applicants can submit the ST25 sequence listing in PDF format. This will exclude the pages from the page fee calculation. Take a moment here. Breathe deeply. If the parent application had a ST26 compliant sequence listing, it can be used for search purposes only in the divisional application. The EPO can add a copy of the earlier sequence listing to the dossier, but the content of the description remains the responsibility of the applicant. Take a breath here. Are you still with me? Now, let's move on to the final section for today. 6. Conversion into a national application. The Central Industrial Property Office of a contracting state must apply its national procedures for the grant of a national patent or another protective right at the request of the applicant. This is provided for under Article 135(1). The request for conversion must be filed within 3 months. If it's not filed in time, the application will lose its effect under Article 66. Let's pause here to let this information settle in. If the request for conversion is filed with the EPO, it must specify the contracting states where national procedures are desired and be accompanied by a conversion fee. Take a deep breath. You're doing amazing. Recap and reflection. Today we've covered the details of sequence listings, including WIPO standards, corrections, divisional applications, and conversion into national applications. Take a moment to reflect on these procedures. In our next session, we'll continue with Part A, Chapter 5. For now, take a deep breath and review today's material. You're making excellent progress. Keep up the great work. Remember, the key to mastering these details is consistent practice and review. Listen to this content as many times as needed. Thank you for your continued dedication. See you in the next session.